Good evening, ladies and gentlemen. I'm Alan Matisow, Associate Director of the Baker Institute, and I'm pleased to invite everybody, to welcome everybody here for tonight's special event. The topic is the International Criminal Court. That turns out to be a very fascinating topic for a number of reasons. For one thing, the American public knows almost nothing about this court. The other thing is it's highly controversial in the political and diplomatic community. I think it's unknown in part because its history is so recent. In 1998, the UN General Assembly convened an international conference, and as a result of that conference, a treaty was written that proposed the creation of an independent court that would prosecute individuals for crimes against humanity, genocide, and war crimes. It's been an independent court which would try individuals who could not be or would not be tried by states. The treaty was negotiated during the tenure of President Clinton. The United States signed the treaty, but the president did not refer it to Congress for approval. And in 2002, when the court began its life, President Bush had that treaty unsigned, leaned on other countries not to participate, to cooperate with the court, and attempted to limit its powers. Currently, President Obama is engaging the court. We're still not members, one of the few countries that are neither have signed it nor ratified it. We're very fortunate today to have Alex Whiting, who is uniquely qualified to talk about this subject. He is currently in the office of the Prosecutor of the International Criminal Court. Not so long ago, I emailed his sister, Sarah Whiting, who is our very successful and wonderful Dean of Architecture. And I said, well, what can you tell me about your brother? And she sent back a message saying that he's been after really, really bad guys for a long time. And that turns out to be true. Alex Whiting got his law degree from Yale in 1990, and almost immediately he began chasing bad guys. From 1991 to 1995, he prosecuted criminals in the Civil Rights Division of the Justice Department. 1995 to 2002, he prosecuted organized crime cases for the U.S. Attorney's Office in Boston. From 2002 to 2007, 2005 to 2007, he was the lead counsel in 3 cases for the Office of the Prosecutor, the International Criminal Tribunal for the former Yugoslavia, which is a different court. Then he stopped prosecuting bad guys for 3 years. He joined the faculty of the Harvard Law School, where he is writing books, as professors do, and also taught courses, one of which is war crimes prosecution. He took a leave of absence from Harvard in 2010, and he's now the deputy to the chief of investigations in the office of the prosecutor of the International Criminal Court. As you can see, Alex Whiting has spent his career preparing to give this lecture. The lecture is the International Criminal Justice, Why Ask Why? So if you would welcome Professor Whiting to our platform.
So I thought I was coming here to speak about this, but in fact I've realized that I've just been brought here to prove that Sarah Whiting has a twin brother and to see whether we look anything alike. Thank you.
Start taking questions now.
Yeah, exactly. The answer to the first question is I am older by 2 minutes. Thank you, Alan. So I've selected as a topic today international criminal justice, why ask why? And what I want to talk about is why we even ask the question whether we should have international criminal justice. Why isn't it self-evident? Why isn't it obvious? What are the reasons that we might not want to have it, or what's the pushback to it? So the talk is going to be in sort of two parts. The first is I'm going to kind of sketch the background of the International Criminal Court and kind of the building blocks of an international criminal justice system. And then the second part, I'm going to engage some of the criticisms or some of the questions about whether we should have this justice. Okay? So, I'm supposed to advance. There we go. So, what if you were a victim of a crime in Houston? What would you expect to have happen? You would, so I have to click twice here. There we go. You would expect that law enforcement and the criminal justice system would become engaged, that the police would investigate the crime, that the judicial system would prosecute it, that there'd be fair process, and that if the perpetrator were identified and prosecuted, that an appropriate punishment would be meted out. And this would be done not just on your behalf as a victim or as a relative of a victim or a survivor, but would be done on behalf of the entire society, right? What if you were suddenly told that this justice was too hard or too expensive, or there were other priorities, or gee, it doesn't really seem to work, and so we're not going to pursue it? What would be your reaction then? And now, what if you are a victim of an international crime? War crime, crime against humanity, genocide. What is your expectation then? What should be your expectation about what's going to happen? So the first question is there a law? For international criminal justice, we need three components, right? We need law, institutions, and enforcement. So first question is there a law? Well, the answer is yes. The law was affirmed at Nuremberg, the first international criminal tribunal. And as the war was drawing to a close, the Allied leaders, here Stalin, Roosevelt, and Churchill, started to think about what was going to happen to the German leaders at the end of the war. And they briefly considered, and very seriously considered, just taking them out and shooting them. But they decided not to do that. They decided to set up a tribunal and try the criminals. And the law that tribunal relied upon was a law that the court found was a law, what we call customary international law. Law created by treaties, by understandings, by practice. It was concluded by the court that all nations understood that war crimes and crimes against humanity, not yet genocide at that time, that came later, but war crimes and crimes against humanity was a crime against nations. It was an international crime, and that individuals could be prosecuted for it. And there's been no serious dispute about that since Nuremberg. That law exists and can be enforced. Justice Jackson was the prosecutor for the United States, and in his opening statement at the trial, he said, famously, "The wrongs that we seek to condemn and punish have been so calculated, so malignant, and so devastating that civilization cannot tolerate their being ignored because it cannot survive their being repeated." It cannot survive their being repeated. What happened after Nuremberg? Well, there were war crimes and crimes against humanity after Nuremberg, but there were no more tribunals for 50 years. And part of the reason for that was because of the Cold War. The countries of the world couldn't come together to agree on punishing crimes that were being committed internationally. And that was the situation until the war in Yugoslavia in 1991. And there were two things that were different about the war in Yugoslavia in 1991. The first is that the Cold War had ended. And the second is that it was in Europe's backyard. So despite what Justice Jackson had said, they cannot be repeated, despite the mantra of never again, it happened again. And it happened in Europe's backyard. And the decisive turning point occurred in the summer of 1992 when there started to be rumors that there were concentration camps in Bosnia. So the Serb leaders in Bosnia defiantly invited journalists, come to Bosnia, come see. They came. The journalists came. And what does this remind you of? What are these images of? Yes, the Holocaust. The Holocaust. So immediately a connection was made with with World War II, and the Nuremberg precedent suddenly seemed possible. And so the Security Council set up the first international tribunal since Nuremberg, the Yugoslavia Tribunal, where I worked for 5.5 years. And it relied upon the law that had been articulated at Nuremberg on war crimes and had been somewhat developed since Nuremberg. But again, no dispute about war crimes, crimes against humanity being a violation of the laws of war. When this court was set up, I don't think many people thought that there would be successful prosecutions. But there were. It far exceeded expectations. Madeleine Albright, who was a big supporter of this court, one of the reasons this court was established, later said about the court, she said, they said there would never be indictees, and then they said there would never be trials, and then they said there would never be convictions, and then they said there would never be sentencings. And at each point along the way, they were wrong. This court indicted 161 war criminals from the former Yugoslavia. Guess how many fugitives there are today of this court? You think they're 10, 20, 30? Zero. Every single fugitive has been captured and brought to The Hague for trial. So then afterwards, the year after, a court was set up for Rwanda, and a series of courts were set up for different conflicts, different atrocities. So Rwanda, the genocide in Rwanda, a court was set up. For Sierra Leone, a special court was set up. A court was set up in Cambodia to try the surviving leaders of the genocide, perpetrators of the genocide in Cambodia. He has just been tried, Doik, and these four are on trial right now for the genocide that occurred in the 1970s. And then finally, a permanent international criminal court was established in The Hague, which has jurisdiction over crimes that occurred after July 1st, 2002. And this is where I work now as a deputy to the chief of investigations. So this court is a culmination in two respects. But remember, we said we had to have the law and the institutions. The law is now codified. It's written down in the statute of the court. So there's no question about what the law is. Everyone knows what the law is, what the crimes are, what the elements are. And the second is we need an institution. We have the institution. It's a permanent court. The court, this is a map which shows the members of the court, the countries that are members of the court. It's a treaty court, so you sign on to be a member of the court. And as Alan said, the United States has not signed on. There are 120 countries that have signed on. 73 countries are not members of the court. The court, the countries that are members of the court have a population of 2.3 billion people. My boss, the prosecutor, likes to say that our court started in the same year that Facebook started. And Facebook is considered one of the most successful, fastest growing companies in the world in all time. Facebook has 800 million members. We have 2.3 billion. Our court has jurisdiction over crimes in 3 different cases. If the crime occurs on the territory of a state party, if the crime is committed by a national of a state party, or if the Security Council gives us jurisdiction over the case, which it has done on 2 occasions for Sudan and last February for Libya. So we have 2 elements. We have the law, we have the institution, we have the courts. What about enforcement, the 3rd necessary element? For enforcement, I have investigators who work for me, about 45 investigators to cover all that blue area. We do not have police powers. We cannot go arrest people around the world. For enforcement, we rely on state cooperation, rely on states to provide us evidence and to provide us enforcement. I'll talk about that a little bit more later, but that is required by the statute, by the treaty that they sign on to. When they sign on to the treaty, they agree to cooperate with the court and with our requests. So what are the major obstacles to this court? And to not to this court, because the court we have lots of problems and lots of, it's hard. It's hard work and lots of logistical problems. But what are the obstacles to the project? What are the obstacles? Why do we still doubt this project? Why are victims not assured of getting justice when they're victims of international criminal justice? Why do people have questions about this? Well, I'm going to talk about 5 things that make people question this project. First is sovereignty. It's all politics. Deterrence? Question mark. Peace versus justice. And the last one is it's too hard. Let's start with sovereignty. This is maybe our biggest problem, our biggest contention in trying to establish our court in our process. And it kind of cuts across a number of the other problems. Sovereignty, the issue about sovereignty actually has 2 sort of dimensions to it. It's about countries wanting to preserve their own power, about making the nation state preeminent in the world, and it being the building block for international relations and for assuring peace. And so sovereignty is an issue for our court in 2 respects. First, it's an issue about control, countries wanting to maintain and exercise control. And secondly, it's an issue about countries having concerns about surrendering their citizens to an international court. But the reality is that this notion of sovereignty is one that has, for the last 100 years or more, already been in transition. It's already been sovereignty has already been challenged in many ways in our globalized international world. And now it is balanced, the preeminence of the nation state is balanced by 2 other things. First, a concern and respect for individual human rights, and that being a focus. And secondly, an understanding that we live in an international world, and that a world where cooperation and international understanding and agreements and treaties are required. And we know there are many ways in which the United States, for example, and other countries surrender pieces of their sovereignty, whether it's through the WTO or through the NAFTA agreement, or it's through treaty organizations. We already have to balance out our asserting an aggressive assertion of sovereignty with trying to live in an international globalized world. In addition, the ICC actually strikes a balance between trying to promote international justice through an international institution and notions of sovereignty. And it does so in two ways. The first is called complementarity. The second is cooperation. So complementarity. We are not a supranational court that sits above states. It's just the opposite. The states have primacy over us. So we only have jurisdiction over a case if a state refuses to investigate or prosecute the case themselves. So if they decide to take care of the case and handle the case and investigate it, and that doesn't mean that it has to be a conviction. If they investigate it and determine that in good faith that there's no case there, that's sufficient. But if they in good faith investigate and prosecute the case themselves, then we have no jurisdiction. There's nothing we can say. We can't second guess them. We can't do the case. So the court, we like to talk about not so much the International Criminal Court, but the Rome system. It is a system of enforcement, a system of courts. And the first barrier, the first port of call in that system is the national jurisdiction. They have the first call. And so in fact, the Rome system gives primacy to sovereignty to the nation state. And then the second thing is we require cooperation, as I said, to do our investigations and prosecutions and to arrest. And so in that way also we have there's an accommodation or a balance with sovereignty. So we like to think that we are not a supranational court that sort of sits way above all the other countries, but that we are part of the judicial system of each country that is a part of our court. And that understanding has been accepted by all the countries, and you can see that almost all of Latin and South America, good part of Africa, all of Europe, part of our court. And they understand and accept that conception. The other thing is that we have to also, I think, recognize that we live in an international global world. And in 2008, Madeleine Albright and William Cohen issued this joint report in which they concluded that genocide and mass atrocities represent an assault on human values and threaten US national interests. And you can imagine the ways that it does that, because it causes massive disruption in the world, which can have consequences on important US interests. But another thing the report said, which I think is critical, is it said that US credibility and leadership are compromised when we fail to work with international partners to prevent genocide and mass atrocities. In other words, it is in our national interest to work with other nations, to cooperate with other nations, to have agreements with other nations to prevent genocide and mass atrocity. We will not succeed. We will not succeed in the long term if we aggressively assert a unipolar type of approach to the world. Alan mentioned that the Bush administration was hostile to the treaty and unsigned the Rome Statute when it took over, and was in fact in the initial years of the Bush administration incredibly not just opposed to the International Criminal Court, but explicitly committed to dismantling the court. We were, wasn't we at the time, but now we were considered kind of an enemy. And John Bolton said in his speech, we should do everything we can to defeat this court from succeeding. And a statute was passed called the American Service Members Protection Act, which is also known as the Hague Invasion Act, because it authorizes U.S. force to invade the Hague if an American serviceman were ever taken to the Hague. But the critical thing is what the Bush administration discovered is that this was ultimately counterproductive for its national interests. And military leaders and other leaders in the administration began to see and complain that this was hindering our relations with our allies and making it complicated to cooperate and deal with our traditional allies in Europe, other parts of the world, who are members of this court and committed to this court. So the Bush administration began to back off of this approach. Not to the point that they were going to sign the treaty, and the Obama administration won't sign the treaty either, I think, or try to get it ratified. But understood that a hostile relationship was not in our interest in this internationalized, globalized world. And in fact, it was the Bush administration which allowed the first UN Security Council referral to our court, which was the Sudan case, which was a dramatic move and a dramatic turn in approach. So on sovereignty, it's complicated, because sovereignty obviously is still an important force in this world, but we're in a time of transition when we're trying to strike a balance between sovereignty and other interests. And the court tries to accommodate that balance, but it's a complicated time. The second objection that we hear about this project is that this is just all politics, that these sorts of cases are really not about the law. It's all about furthering politics through another means. And this sort of skepticism takes several forms. The first is that if we return to our map, we see, of course, that not all countries are part of the court. And so it creates the perception that justice is going to be applied in some places but not in others. And the fear, of course, is that the big and powerful countries will not be subject to international law. It's only going to be the weaker countries that are going to be subject to international criminal law. And to make, oops. I think I lost my slide. Hang on. Oh yeah, no, here we go. To compound matters, as I've mentioned, the ICC can get jurisdiction from the Security Council. The Security Council is a political body. And so last February, we got the case in Libya. But in Syria, things are happening which are as bad, and many people would say worse, than what happened in Libya at the time we got the case. The Syria case has not been referred to us by the Security Council. And I suspect that many of you would think that we shouldn't be holding our breath to get that case. And the impression, of course, is that these decisions about which cases we're going to get, which cases we're not going to get, are not based on law, but are based on political interests, economic interests. So it's not just that the law will be applied only to the weaker states and not to the powerful states, but that even with respect to the weaker states, the decisions are going to be based on non-legal considerations. And then, to make the matters even worse, these crimes are committed in the context of intense social, political, economic division, war. And in that context, countries where we try to prosecute cases, they are going to take a political stance towards us. That's my boss, the prosecutor, Luis Ocampo. Some unfavorable, shall we say, depictions of him in Sudan, right? And so sometimes the countries ally against us, like in Sudan, to some extent, maybe in Kenya. In other cases, some in the country support us, others don't. But it becomes very, in the context of tremendous social division and economic and upheaval, we become kind of a political football in the discourse of that country. So that furthers the perception that we're politicized. I'll say just a few things about this problem of politicized justice. The first is that in doing our work, the way we approach our work is to follow the law and to apply the law. We are engaged not in a political process, but in a legal process. We look at the cases, we decide if they fit the jurisdiction, whether they fit the law, whether we have evidence, and each step we apply the law. So we do not engage in a political process. The second thing is that to some extent these objections, this problem about politicized justice comes with doing big cases, comes with the territory. And it happens even in domestic cases. You can think about some of our big domestic cases, whether it's O.J. Simpson or Scooter Libby or Rodney King. Those cases also start to have political debates and undercurrents. The other thing is, I think ultimately, this is an objection that is not so much an objection to the project itself, rather it's an objection to how the project is done. And the principal reason for this objection is that we have not yet achieved universality with our court. If we, and I'm hopeful about that, of course, that one day all countries in the world will be members of the International Criminal Court. It won't be tomorrow. But if we can achieve that or get close to that, then that will go a long way to taking away the accusations of politicized justice. And then finally, and I think this is really important, our court is not just about the cases that we do. Our court is about, because we will do very few cases. We have resources to do very few cases. It's about being part of this Rome system that will encourage national jurisdictions to do cases. But even further, and more importantly, it's about keeping this subject front and center about justice for international crimes and framing the debate about justice and about developing norms that will be enforced through a variety of ways to ensure that these crimes either do not occur or are punished afterwards. So the idea is that we are part of a bigger project. And I can tell you that those norms, although the big powers are not part of the court, it's not just the United States, India, Russia, China, also not members of the court, but the norms that are being developed by this project, and the principal norm is that you cannot retain political power through the commission of atrocities. That's the norm that we are aiming to develop and enforce. That norm also constrains the big powers. That constrains the United States and China, and to greater or lesser degrees in different situations, but those norms have a powerful effect. Now, the third objection that we come across is effectiveness, whether we are effective as a court, right? And although we've only been at this business in the modern era for 18 years, 18 years, think of that. We've been doing domestic criminal justice for hundreds of years, right? 18 years, and people are always saying, well, what are the results? What have you stopped? What crimes have you stopped? What is the effectiveness? There's already a concern about whether we can be effective. And the biggest thing that people look at is deterrence. Now we serve a number of purposes. It's justice for the victims, it's retribution, it's affirming a moral stance. But people want to know if we are going to deter crimes in the future. And that seems to be the biggest measure of our court. And the question usually gets posed like this: is it really plausible that you're going to stop the next Slobodan Milosevic or Charles Taylor or Saddam Hussein? Are they really looking at this court and listening to that? So I'd offer a number of responses to this concern. The first is that deterrence is an issue also in domestic criminal justice systems. Right? Let's look at this chart in Houston. This is a chart of violent crime in Houston, right? And you see 1990, you see the numbers are sort of the same, right? And you might look at that and say, well, we're sure prosecuting a lot of people in Houston, but it doesn't seem to be having that much of an effect, right? Should we keep doing this? Maybe we should just stop. So deterrence is a famously hard thing to prove, whether it's for domestic or international. The second thing is that, as I said before, it's not just about prosecuting the leaders, even though that's what we do. It's about the effect that has, and the larger effect of the Rome system, and about the creation of the norms. So what I think you can say we've seen in the last 20 years is political upheaval and leaders being called to account within the justice system. So whether it's Saddam Hussein being put on trial, or Mubarak being put on trial, or if you look at Libya, the discourse and the language it's about trials, it's about justice, it's about accountability. And I love this. This is a great image. These are our 3 suspects that we charged at the International Criminal Court. And that, I think, that change in discourse, which we're not, the International Criminal Court is not solely responsible for, but we're part of that process, is, I think, what is will give hope for deterrence in the future. And it's not that the leaders necessary, that the next nationalist leader is going to be deterred, but these crimes require hundreds of people to be committed. Hundreds of people have to participate, thousands of people. And the hope is that the creation of the norms, the enforcement of the norms, whether it's through our court or through domestic courts, will deter those actors, the smaller actors. And I think there's some evidence to show that that's happened. One thing that we see is that more and more atrocities are being committed not by regularized armies, but by militias. And oftentimes armies will join up with militias that are not trained, and the armies won't commit the crimes. They're kind of trained, and they're not, but the militias will do it. There's some evidence that training and professionalism will have a deterrent effect on the smaller actors. There is also anecdotal evidence that we've seen that some of the militia leaders and war criminals are in fact paying attention to our court. Some of the people captured around Joseph Kony have said that Joseph Kony is obsessed with the International Criminal Court and talks about it all the time, is trying to find out what's happened. So we're beginning to see, I think, some effect in kind of the ranks, and maybe even in some of the militias. And over time, hopefully, we'll achieve some measure of deterrence. And then one last point about deterrence and international criminal justice is to reframe the issue a little bit in terms and not talk about not talk about mass atrocities, but talk about terrorism, right? Because that's what this is. That's what these international crimes are. They're terrorist acts. By definition, they're attacks on civilians for political power. So remember Justice Jackson at Nuremberg? I quoted his opening speech. Well, he also said in that speech, he said this: we will show them, speaking of the defendants, we will show them to be living symbols of racial hatreds, of terrorism, and violence. This is Dragomir Milosevic. This is one of the people I prosecuted in The Hague at the Yugoslavia Tribunal. Convicted, he's one of the generals responsible for the siege of Sarajevo from 1992 to 1995, one of two generals responsible for that. He was convicted of inflicting terror on civilians and sentenced to 29 years. This is terrorism. And when we think about terrorism, I think there's a consensus. I think it's understood that terrorism is going to be fought by a variety of tools. It's going to be fought by the criminal justice system. It's going to be fought by military tools. It's going to be fought by intelligence. And in some cases, it's going to be fought by diplomacy. It's the same with mass atrocities. It's the same with war crimes and crimes against humanity and genocide. Those have to be fought with the same tools. And it is the combined effort of those tools that will deter them and stop them and prevent them. The fourth objection that we get is the peace versus justice objection. And this, interestingly enough, is an objection that comes often from all sides. Even you might say liberals, human rights proponents will sometimes want us to stop our prosecutions because they're concerned that it interferes with the peace process. In Libya, we received the referral of the case in Libya in February of last year. We brought arrest warrants in May of that year against 3 people, Gaddafi, his son, and another person. In June, there started to be rumblings that some of the countries wanted to negotiate, and they saw us as an impediment to negotiation. And so that we interfere with the peace process and we cause leaders to dig in, and that if we really want to prevent atrocity, we should make peace with these leaders, give them immunity, let them go to exile, stop the atrocities rather than trying to prosecute them. Well, this is a very complicated issue. We, as a court, will not get involved in those discussions. As I said, we will follow the law. If it's up to other actors to consider diplomacy and peace. That's not our job. We can't get involved in that. But I will say that before nearly every major indictment of a war criminal, this argument was made. Whether it was Slobodan Milosevic, Charles Taylor, others, it's always said, oh, if you do that, if you indict them, then the war is going to continue. But in fact, what happens is that when that marker is put down, the diplomats adjust, and the international leaders adjust around the law. They ask us to adjust. They ask the law to adjust to them. But if we stay firm, they end up adjusting. And in Libya, for example, I don't think it would have been a better outcome if there had been a negotiated settlement with Gaddafi halfway through the war. And he were allowed to go into exile, and some of his people were allowed to keep power. So it's our view that that justice is essential for peace. It's a building block for peace. And that diplomats, it's going to be essential for diplomats to, you have to show you this, be essential for diplomats to adjust to us, to adjust to the law. The last thing, and then I'm really like to take some questions. The last objection we get is that it's too hard. This project is too hard. It's too big, it's too hard. And this comes in 2 forms, right? The first is that there are too many people to prosecute. How are you going to prosecute all those people? There are hundreds of people to prosecute. You're never going to be, so forget it. Let's not prosecute anybody, right? And the reality is that our court will only prosecute a few people from each mass atrocity, from whether it be Congo or Uganda or Kenya. And the reality is that not everybody will be prosecuted. That is just a reality of this business. And it is up to the country where these crimes occur to determine whether other actors, whether the lesser actors are going to be prosecuted, whether there'll be some other process that occurs. But that is just a reality that has to be accepted. It's not a reason not to do it. It's just the reality. The second objection we get is that it's too expensive. So the question I have for you as I conclude is, if you took our annual budget for the International Criminal Court, for the whole court, how much of the war in Afghanistan do you think it would fund? Anybody want to take a guess? 1 day? You think a day? 12 hours. Our annual budget, 12 hours of the war in Afghanistan. So these different objections, these different concerns about our court, this political, deterrence, sovereignty, these are all the environment that we operate in. And we have an uncertain place in the world right now. Nuremberg happened. If people thought that was going to be a precedent, 50 years went by and nothing happened. Then there was a second wave of courts, individual courts for different countries, Yugoslavia, Rwanda. Those were very successful. And now we're in the third wave. The third wave is a permanent court for the world. And it's a time of tremendous transition and uncertainty. Whether we will succeed, whether in 20 years, 50 years, will all the countries be members of the court, or will we be a marginal, ineffectual body? It's a moment of transition, a moment of uncertainty, and all of these issues that I've talked about are the things that we confront and that we struggle with. But at the end of the day, what I would say is that if for some reason we conclude that it can't be done, that it's too hard, that it's too political, then it'll be up to us to look in the eyes of the victims, right, and say to them that justice cannot be done, that justice is not available for you. I hope that won't be the case, and I'm confident, in fact,